Hello, my learning friends. Welcome to HipHughes History, where we're going old school on you with the Judiciary Act of 1789. Why? Because it's on the exam. So why don't we go giddy up for the learning and go get it done right now. Why don't we start with the Constitution? Because that's where all good things start, at least in political science. The Judiciary Act of 1789 doesn't exist without this conversation. So you have to remember there's a divide, right? There is people in the Constitutional Convention that are all gung-ho about a federal court, because the federal court is, in a sense, the enforcement arm of federal supremacy. What good is federal supremacy if there's no court system to enact it? While you have anti-feds at the convention who are like, no way, man! I don't want tyranny in these black robes. And especially when you look at the Constitution and you see that these dudes and now dudettes have lifetime appointments, there is a fear that they can go a little rampant and there's not going to be a lot of accountability. You can see these fears of the anti-feds are going to be partially addressed in half of the Bill of Rights. Half! They got half. They got 4, they got 5, they got 6, they got 7, they got 8, all dealing with the federal judiciary. So at the end of the day, what you do get is you get Article 3, Section 1, and why don't we just read you the flowery language now? The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may time to time ordain and establish. So that's all we get. We get one Supreme Court. Well, how many are on it? I don't know. Well, are there other courts? I don't know yet. Well, what exactly do they do? I don't know. That's going to be up to the Judiciary Act of 1789. You see how I led you like a horse to the water? So now why don't we drink from the trough of learning? Oliver Ellsworth, that is the man who wrote the Federal Judiciary Act of 1789, and this is going to be in the first U.S. Congress. That's right, number one, uno, the first one, because is in a sense defining the mechanism of government and who's going to be the most powerful man in the world. Well, in the United States, it's going to be George Washington, because all of these new offices and new judicial roles that are being created are all going to be filled by the big man himself. So let's get right to the butter. Let's cut to the chase. Let's open the gift and talk about specifically what that act did. Biggest one is going to be defining the Supreme Court, and they're going to put the number at 6. There were 6 justices in the original Supreme Court. 5 of them are considered to be associate judges, and then there'll be one chief judge. And the chief judge has to be named because they play a role in the actual Constitution when it comes to things like holding the impeachment trial in the Senate. So 1 Chief Justice, 5 associates. Now it's going to define original jurisdiction, where you're going to have civil actions between states or one citizen and another state, and it's also going to deal with all suits versus ambassadors and diplomatic staff and such like that. And of course, they'll have appellate power over these newly created courts, and this is where we get those inferior courts that we were talking about previously, and they're going to be divided into 13 judicial districts. You would think one for each state, and you would think wrong. It was North Carolina and Rhode Island hadn't ratified the Constitution, so the 13 actually comes from 11 of the states, and then Massachusetts got 2. They got 1 for this little place called Maine, which isn't a state again, and I believe Virginia got another one for a place called Kentucky that wasn't a state again. But these 13 judicial districts are going to be composed of what's going to be called a circuit court. There'll be 13 of those, and 13 district courts. These circuit courts are going to deal with more serious crimes and more cha-ching when it comes to civil trials, and the district courts are going to hear kind of petty offenses and financial civil cases which are less in value. And like I said before, the circuit courts are going to have appellate authority. They're going to be able to hear appeals on cases that come from those lower district courts. But one thing is for sure, in the original Judiciary Act of 1789, there is no federal question jurisdiction. So you can't can't have a claim that your constitutional rights are being violated and go to one of these courts. That's not going to come till later. It actually first came in 1803 and went away, 1875. It's back, baby. But now we have arms of the federal government in each state. But I'm not done yet. They weren't done cooking stuff up. They're going to create the Office of Attorney General. We're going to have the Attorney General, which is going to be a cabinet position. We're going to have a U.S. attorney. And originally they were just meant to kind of be the representational forces for the United States government went to the Supreme Court. But they're also going to create a marshal, a district marshal for each of these judicial systems. So in a sense, they'll be the long arm of the law. So that's basically the Judiciary Act of 1789. But Houston, we do have a problem. So Houston, here's the problem. One of the provisions of the Judiciary Act of 1789 was that it expanded upon original jurisdiction for the Supreme Court. These are cases that go directly to the Supreme Court. They're not heard on appeal. And that addition involves something called giving the court the ability to do writs of mandamus. Mandamus. What an awesome word. And I think also an awesome name for a baby. That was free if you're looking for a baby name. So this is going to come to play in 1803 in a court case that you're going to have to know if you're in any kind of U.S. history or government course. And that is Marbury versus Madison. I feel like I need a dramatic drum roll before I say that. Marbury versus Madison. And in this court case, the basic precedent is that it gives the Supreme Court the ability to rule on congressional actions and then to overturn them. And that's what they did in Marbury versus Madison. And what did they overturn, you might ask? What piece of legislation were they looking at? Yeah, you got it. It was the writ of mandamus in the Judiciary Act of 1789. So now that that's all cleared up, you understand, hopefully, why it was flawed and why that flaw is going to lead to Marbury versus Madison, why that is so fundamental because it creates judicial review, which is why you have a huge list of Supreme Court cases. All right, why don't we wrap this bad boy up? So, of course, the Judiciary Act of 1789 has been updated many times. Today we have 13 districts with 13 federal court of appeals, but we also have 94 district courts that are broken up into 12 circuit court systems, each with their own court of appeal, which means there's just a lot more black robes out there. So that's all I got for you. We hope your brain's a lot bigger. We certainly hope you pass your test. And make sure if you haven't checked out our video arsenal, we probably have the video that you're looking for. Just check us out at www.hiphughes.com. You can navigate to the video arsenal and go scroll through the various topics. And if you haven't subscribed, I don't even want to be looking at your face right now. You should be ashamed of yourself. How dare! You're not supposed to get mad at the people who watch your videos. You're beautiful and I love you. All right, my friends, we'll see you next time that you press my buttons, and always remember it because I believe it with all of my heart. Where attention goes, energy flows.